Welcome to the final session in this three-part series looking at securing a market for your drug beyond patent protection. I'm Ian Jones, a UK and European patent attorney and senior associate at Gill Jennings Every, a European intellectual property firm focusing on patents, trademarks, and designs. In the first two sessions, we saw how SPCs can be used to increase the duration of market exclusivity for a marketable drug in Europe. In this session, we're going to explore the use of data and marketing exclusivity together with orphan designations to maintain market exclusivity for your medicine. In Europe, holders of an initial marketing authorization for a medicine have a period of 8 years from its grant during which they can benefit from the exclusive right to the results of preclinical testing and clinical trials on the medicine. This means that a generic, hybrid, or biosimilar cannot be validated by the relevant regulatory body. They also have a 10-year period of marketing exclusivity from the marketing authorization date. However, if the holder receives an authorization for a new indication in the first 8 years, the market exclusivity is extended to 11 years. Although that new indication has to have a significant clinical benefit in comparison with the existing therapies in terms of improved efficacy or safety, or it has to offer a major contribution to patient care. This is unless there are no existing therapies, in which case the extra year is granted. During that time, a generic, hybrid, or biosimilar can't be placed on the market. These two durations run concurrently, so this means that the generics manufacturers may only start to apply for approval of a generic version of a drug using the bridge procedure only 8 years after the original medicine was approved, and launch their own approved generic in the European market only 10 years or possibly 11 years after the original medicine was approved. This is, of course, assuming that patent and SPC protection has expired. For this reason, this form of exclusivity is often referred to as the 8+2+1. You get 8 years of data exclusivity, the remaining 2 years of market exclusivity, plus the potential for an additional year. So is there any effect for Brexit on this? Well, only in terms of the strategy you may apply. Marketing authorizations from the EMA were converted into UK marketing authorizations on the 1st of January 2021. Those conversions acquire the same grant date as the original authorizations issued by the EMA. And so the clock counting down the 8+2+1 remains unchanged. However, you can now have separate GB and Northern Ireland marketing authorizations, as we heard about in the second session. And so it's important to adopt a strategy to maximize your potential period of exclusivity. For Northern Ireland, the application of the Northern Ireland Protocol means that regulatory data exclusivity will be determined by the date of either any centralized EU marketing authorization, such as one issued by the EMA, authorizations anywhere in the EEA, which of course is broader than the EU, and in time as authorizations diverge, any UK authorized product. Current thinking is that if authorizations are issued in both the EEA and the UK, both of which apply to the Northern Ireland, as opposed to the GB authorization, which does not, then the clock starts ticking from the earliest marketing authorization, although I'm sure this is going to be tested in the courts in time. Another point to mention is that when obtaining a UK-wide marketing authorization, the Northern Ireland requirements will apply rather than any purely national UK requirements, should there be any difference in future. In view of this, applicants for marketing authorizations in the UK will want to determine whether they may obtain longer periods of exclusivity by submitting separate GB and Northern Ireland marketing authorizations compared to a single UK marketing authorization, with the latter having to follow the EU rules. We can now look at orphan exclusivity. This applies to rare diseases and conditions that lack appropriate treatment. These markets are often seen as economically uninteresting due to the lack of return on investment. Orphan designation is given to stimulate research and development of orphan products by providing appropriate incentives. An orphan medicine gains 10 years of market exclusivity plus an additional 2 years of market exclusivity for the completion of a Pediatric Investigation Plan, PIP. It's important to note that this market exclusivity is against similar medicines with similar indications once they are approved. Orphan designations offer additional benefits to a company, such as greater assistance throughout development and the authorization process, and a reduction in authorization fees. Finally, it's possible for a single medicine to have multiple orphan designations, each with their own 10+2 market exclusivity clock. So now we can add back in the patent and SPC protection from the first two sessions and look at the full picture. If a first marketing authorization is issued before expiry of the patent term, then we have the option for a 5 or 5.5 years of SPC protection following the expiry of the patent. The market authorization also starts the clock for an 8+2+1 years of exclusivity offered by data and marketing exclusivity. We can also consider whether your drug may be eligible for the 10 or 12 years of exclusivity offered by orphan designation. Now, each of these exclusivity periods are likely to overlap. However, each point should be considered as part of your company's IP strategy to maximize the revenue generated by your medicinal product. This brings to a close this third part in this series looking at securing the market for your drug beyond patent protection.